Welcome to FDA Imports, cross-border compliance with attorney Benjamin L. England.
Hello, everyone. Welcome to FDA Imports, cross-border compliance with attorney Benjamin L. England. Ben is the founder of FDAImports.com and a former FDA regulatory counsel who helps companies worldwide navigate the complex intersection of FDA oversight and international trade. I'm Sean O'Connor, and today we're talking about voluntary disclosures of FDA and Customs and how deciding whether to self-report can significantly affect a company's exposure. Ben, how are you?
Oh, great. Thanks, Sean. Good to see you. Glad I could be here.
Yeah, and I feel like we recently were talking about, what happens when you maybe discover you've made a mistake or that sort of thing in your paperwork. What does a voluntary disclosure mean in the context of FDA and Customs enforcement, and how does it differ between the two agencies? Evidently, they handle it differently.
Yeah, very much so. So, in the case of FDA, we'll start there. In the case of the Food and Drug Administration, there are circumstances where you're obligated to tell the government about something related to the product where there's a safety related issue. All right. So let's sort of take it away from the border and just sort of think of it in terms of safety related problems. So I'm importing a food, I'm distributing a food that was imported, and it turns out that food, someone consumes it and then they get sick. And there was an epidemiological study, there was a traceback that was done, and there's a determination that there's a link between the food that I imported and somebody's illness. That information makes its way to me, right? Through consumer complaints. It may make its way through some formal mechanism or an informal mechanism. I learn about it.
You being the manufacturer or you being the importer?
Well, so the importer is, or very often, the closest person to the consumer in the United States. And so to the extent that the importer is known, and it's not uncommon that the importer and the brand associated with the product are not necessarily owned by the manufacturer. So the manufacturer's name may not appear on the label. Maybe mine does because I'm the distributor. And in food labeling, drug labeling, cosmetics, devices, everything in the food and drug world, you're obligated to put on the label the name of the manufacturer, packer, or distributor. Some countries require you to have the manufacturer and the distributor if it's different, but not the U.S. Right. So if I'm the importer distributor, it's not uncommon that it might have distributed by Ben England's food company, product of India. Okay, yeah. So it's got my name, my address, but it's product of India. Now let's say someone gets sick. The reason that my information or somebody's information has to be on that label is because there is a problem. They have to be able to get a hold of you, so they'll probably reach me, and so they'll get a hold of me, and there'll be some problem. Now, what I have to do a couple of things. I have to first. I should have a system in place that's able to handle complaints. Right? It's obligatory for me to be able to identify when there's an important information coming in about a product. If it's about manufacturing, there's little I can do other than to pass it on to the manufacturer. But if it's about something I have done or the labeling is wrong or something like that, and it's my labeling, then maybe there's something I can do about it. But in the case of a safety issue, I have to assess whether or not the problem is what would be designated by FDA or classified as a Class 1 recall. And these are the bad ones. These are the ones that would cause illness and could cause death. So if you think in terms of bacterial contamination or some chemical poisoning, that's a serious poisoning. So if that happens, if there is a Class 1 level of recall, I have an obligation to report to the FDA that information. All right. Now that has nothing to do with whether it's imported. That's just a safety related compliance requirement. Another example would be, I'm in the drug business and I'm importing or I'm distributing pharmaceuticals and I'm a wholesaler, and I get information that comes back to me, or I receive a drug that appears like it could be questionable, right? It's a suspect drug. Maybe the way it's been handled, or maybe the way that it's been labeled, or maybe it looks like it could be counterfeit. And if I have a suspicious product, then I have certain reporting obligations. Now let's put it into the world of imports. For the most part, importers tend not to be that close to the consumer, right? There tends to be either a distributor or at least a retailer. Now that's not true if I'm selling on direct to consumer, internet, based systems, right? Think the big ones, right? The really big places where everybody goes online to buy stuff. Well, what do? They buy foods, they buy cosmetics, they buy over-the-counter drugs, they buy medical devices, they buy FDA regulated goods. I, as the importer, might be the closest person to that consumer, because it's coming into me, and then I'm doing the fulfillment and the pick and pack. So I might very well have more obligations than I would otherwise, because there's no distributor or brick and mortar retailer between me and the consumer. Right? Now, but all of this has nothing to do with the border. It turns out that if I import something and I make a mistake related to FDA requirements, there is no system or no regulation, no guidance that requires me to tell the FDA, which is pretty interesting, right? It turns out, right? Customs is different. If you make a mistake in customs declarations, and it could be like a classification issue, particularly if it has to do with duty, right? Duty or intellectual property. I bring in something and I bring in a counterfeit product of your brand, right? So, and it comes in and the information doesn't properly go into customs, and it turns out that there's a problem with the intellectual property or the classification, which affects duty. Then I might have a prior disclosure obligation, and customs actually has a whole system for that, whereas FDA doesn't. So they're treated very, very differently, and we can sort of talk through the mechanics. But if it's a safety related issue, it's not about imports; it's about the safety, and that may have a reporting obligation. So it doesn't matter if it's imports for FDA. But if it's a customs issue and it has to do with duty, then money, right? Then probably customs cares.
Got it. And so I'm wondering, in terms of these disclosures. In what situation does, say, voluntary disclosure tend to reduce risk, and when can it actually potentially create additional exposure?
Yep. So good way to think about it. First, we're using the word voluntary here. When you talk about a safety risk, like a class 1 situation for a recall, that's mandatory disclosure, right? Non-voluntary. There is no voluntary disclosure system in the Food and Drug Administration.
Okay.
Now, that doesn't mean people don't do it. And I can give you some examples. Like I bring something in and FDA releases it. And let's say it takes FDA too long to do something and it's a perishable item, right? So FDA gets around to release into cargo. And by the time they released it, it's perished, right? Yeah. I mean, now it's adulterated and it wasn't before, right? So this might be something I disclose to FDA, because I might actually, when FDA actually detain it, refuse it, because I might have a commercial reason why I want to send it back or make a claim against the foreign supplier. So so I might have some reason that I would want to do that. Now, in that case, it's not my fault. It's actually the FDA's fault. In circumstances where it's my fault, I failed to declare something that I should have declared, and then the government relies upon that and does something with it, right? So let's say a product is on import alert. An import alert exists because a foreign manufacturer and its products, or a specific product from a particular region, FDA has evidence that there could be an adulteration issue, like a pesticide problem with certain products coming from a certain area, or animal drug problem, in seafood or something. And so my product would ordinarily be detained, but FDA screening misses it, right? And it gets through. I'm not actually obligated to tell anything to the FDA, but I might tell them anyway. And the reason I might is because if FDA figures out that it got through, they have 30 days to fix their release. And if they fix that release within 30 days, then Customs is going to demand redelivery of that cargo. And I may have to answer to Customs for failing to redeliver. So even though FDA would rarely ask for goods to come back if I didn't make a mistake. If they made a mistake, right, they wanted to sample it, but it got through. In those circumstances, I might go to the FDA and say, look, you made a mistake. We released the cargo because you gave us a release, and the goods are gone. So, I mean, I don't know why you would think I would have them anymore. And they would say, is there anything left? And I would say yes or no. And if there is, they might want to come look at it. Well, what am I doing? I'm really being a good player is what I'm doing, right? I'm really showing the government that I have nothing to hide. I have nothing to be concerned about. But it might be that shipment is intended for my biggest customer, and they've just made extra orders, and those orders got jammed up in another port. and I can't get them, and they can't get them in, so they're turning to me because they really need those orders. It also might be that I have a deadline and I have to get that product to a big retailer, or I pay rent on the empty space, right?
Yeah.
So if I don't get it to the big retailer and that shelf stays empty, they charge me for that, right? So there's money to that, right? Well, now I might decide, look, I'm going to go ahead and ship the cargo. And I'm sort of taking a risk, a calculated risk. So that's sort of in the FDA space. In the custom space, you might decide to do a prior disclosure because you think you might have made a mistake and you don't want penalties, which are not the same thing as duty, right? So if I made a mistake and the wrong duty was charged, I didn't pay enough duty, then I even though I don't really want to pay the duty, I should pay the duty. In fact, I kind of have to pay the duty. If I go to customs, if I don't say anything, and then customs comes back later and says, hey, you didn't pay the duty on this. You gave us the wrong information. It was improperly cleared. We're going to, not only are you going to pay me the duty, you're going to pay 2 times the duty, right? Well, that's a penalty, right? That's the extra money. So I don't want that. And the way that I might avoid that would be a prior disclosure, right? Prior disclosures cut off penalties. It doesn't cut off the duty, right? But it does cut off the penalties. So I might make a decision. Look, I'm going to do a prior disclosure because I don't want to have any penalties. And they're going to eventually figure it out.
Yeah, that makes sense. Like, I mean, I happen to just get a notice from the IRS, and they're like, hey, you miscalculated, you owe us more money. And also, by the way, we're going to penalize you for the, charge some interest because,
and
X amount of time is passed.
And that's actually a very good analogy because under those circumstances, you might get on the phone, you might talk to the IRS, and you might talk them out of the interest or the penalties, but you won't talk them out of the tax, right?
Right.
And so duty is a tax. And so it might be you could convince customs to not charge you. By the way, customs charges you interest if you fail to pay duty on time, just like the IRS. It's exactly the same. So you might talk them out of the interest and you might talk them out of the penalties, but you're not going to talk them out of the duty. Almost never. I mean, it would have to be. I'm trying to think. I think it may be one case I can think of where where
doesn't happen.
It's just, they don't do it.
Well, speaking of that, really, what kinds of issues are generally appropriate, for voluntary disclosure, and which ones would you want to have a different strategy?
So in the FDA space, I would say, let's go back to the import alert issue and we'll change the facts a little bit. The foreign supplier is on import alert for a particular product, which means the FDA is going to automatically detain it. Now, FDA doesn't call them automatic detentions, but they are as automatic as they get, basically. Like it comes in and it just gets automatically detained, right? So that's pretty automatic. The reason they're not supposed to call it an automatic detention is because they've been sued several times and I've sued them. And when they do that, then they're treating it like a regulation and they're not allowed to do that, because it's automatic, right? And so regulations are automatic. It's supposed to be guidance. So I have a product that's on import alert. It comes in, FDA lets it go. I actually want FDA to detain it. I want FDA to detain it because I already have put together a root cause analysis for the manufacturer. I've already done a corrective and preventive action plan, a CAPA. So I already know my facility's under control, and I'm going to petition FDA to get them off of the import alert. Well, to do that, the next thing I need to do is have some clean entries. And those clean entries prove that my RCA, my root cause analysis, was correct and my CAPA was effective. If I don't have any clean shipments that I can point to here in the United States, I could run into a problem where I can't prove that it worked and it hurts my petition. So I actually don't want FDA to release it. I want FDA to detain it. I'll send it to a private lab or I'll do whatever it is I have to do in order to show the FDA that it worked. And then I'm going to submit that information. Then I get the release, and I have to do this enough times to satisfy FDA that the whole thing is working. So that's a situation where I definitely would want to. If it turns out that I'm not that far and FDA has released it, because of what I said before, import alerts are not regulations and FDA cannot treat them like a regulation. I'm entitled to rely on an FDA release because there's no reason for me to believe that they didn't act with discretion and let it go. So I can release that cargo, but I run the risk of FDA figuring it out and demanding it back, right? That goes back to the 30-day time window. So those are two examples where I would definitely tell FDA, and others where I'm going to try to figure it out. With customs, So it might not be a money issue. Sometimes it's a census issue. Customs collects data for the census, and census then takes that information and they use it to sort of project trade and to identify where products come from. Also to identify the kinds of things that are coming in for the U.S. market from different places. And so that information is actually like you can have a mistake in your census data, and you probably don't have to worry about it. But if you've made a claim that there's a free trade agreement that applies to your product, and that's not correct, then you've probably paid the wrong duty, right? You might have not paid any duty. You might be under a complete free trade agreement, and the goods are actually zero, and they should be 6.8 or whatever, right? So those circumstances, you're going to have to think seriously about it, because if you fail to do it and they catch it, that's the situation where you can run into a penalty action. You run into, it's going to cost you more than just the goods. At the same time, right, if you have, like with customs, a free trade agreement issue, right, as opposed to some other census issue. With a free trade agreement, if I have improperly declared that a free trade agreement applies to my goods, then I might have paid zero duty. And whereas with census, I might get away with not doing a prior disclosure. It might not be that big of a deal, but technically it is something you're supposed to tell customs. Then it probably is not going to matter as much. But if it's a free trade agreement and it affects duty, and I should have paid 6.8% or 7.4 or 3.8, and instead I paid zero, those are circumstances I look at very, very closely. The other thing that's important about it is if it turns out that customs opens an investigation. I talked in another podcast about CF-28s and CF-29s. If customs issues a CF-29 and they've opened an investigation and they want to determine whether this is a repeat problem, they can go back 7 years. So if it turns out my classification is wrong and it's been wrong for a long time, they can go back and get all that money with interest and now with penalties. So it could be a lot of money. So I would say that there are circumstances between the two agencies where you may or you may not decide to disclose. Again, there's no mandatory disclosure with respect to FDA. It's technically not a mandatory disclosure for prior disclosures with customs. It's just that if you don't do it, then you're going to lose some benefits for having not done so. Right? This is the fact that penalties would still be applicable. So I guess it's voluntary-ish, right, in that sense. But it is also a judgment call. Look, the companies make these decisions all the time. People make mistakes, and it happens a lot. And so a lot of times people come to me and they'll say, "Here's my situation. What do you think we should do?" Well, I want to know, how much money are we talking about? How long do you think it's been going on? Have you changed anything in your entries recently? Have you ever asked customs? Has customs ever asked you? I'm going to want to know some things. In order to assess and then tell them, all right, here's where I think your risks are. This is what I think I would. And in fact, I'm going to, a little sort of secret here, right? When I talk to a client, most attorneys will say, you have to make the decision. All I can do is say what the law is. Well, I'm a CEO that happens to be a lawyer. So the way I'll approach that is going to be, I'll say, do you want to know what I would do if I was in your circumstances? You're still going to do what you're going to do, but here's what I would do, and here's why I would do it. But you need to decide what you're going to do. And that gives them a little context to figure out sort of the risk, like what sort of risk tolerance that they should have.
Yeah. I mean, it's complex, and there's cost benefit analysis, and, and different individuals and different companies have a different tolerance for the risks. And then, like you said, that what's their track record with customs or,
that plays into it. The other thing that's interesting is culture. It turns out, because we're dealing with people from other countries a lot of times, the cultures are very, very different in terms of their risk tolerance. And I start learning that because I have clients all over the world. And so I sort of know the direction that one company is going to go because of where they're from. And I have a sense of what the other company is going to do, and they could be vastly different, right? Some are much, much higher risk, to have a much higher risk tolerance than others that are very, very compliance focused. And and so that helps me communicate with them also, right? Because I understand not just what the risks are with respect to the product and the problems and the enforcement, but I also have a pretty good feel for what they're probably going to be able to tolerate.
Yeah, that makes sense. Yeah, the cultural difference. Wouldn't even have thought of that. Well, listen, Ben, fascinating as always. We're out of time. Good to see you.
Likewise.
That's it. for today's episode of FDA Imports Cross-Border Compliance. If your company is weighing whether to self-report an issue to FDA or Customs or responding to an enforcement action where disclosure is on the table, visit FDAImports.com to connect with Ben and his team. And if this episode was helpful, be sure to subscribe or leave a review, share it with a colleague who is responsible for compliance decisions. That'd be real helpful. I'm Sean O'Connor. Have a great day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.